I guess we can start now. Is everybody on board again? So allow me to introduce our next speaker, who will talk about mediation. He is the principal mediator of the Singapore Construction Mediation Center and the master mediator of the Community Mediation Center. Mr. Lee Kong Eng serves as principal mediator with Singapore Mediation Center, handling commercial disputes ranging from construction claims, building defects disputes, real estate, property, landlord and tenant matters, contractual matters, commercial matters, employment-related matters, as well as insurance claims, oil and gas industries matters, and including family matters. Well, that's a big responsibility if it includes family matters. As the principal mediator with the Singapore Construction Mediation Center, he is currently handling construction disputes of Singapore Contractors Association Limited or SCAL members. He is one of the founding committee members of Consumers Association of Singapore's panel of mediators, and also one of the founding members of the International Institute of Mediators, Singapore Limited, or IIM. He is an accredited mediator with the Singapore Institute of Surveyors and Values, and a certified mediator of the International Mediation Institute, or IMI, since 2010, as well as a certified mediator of Singapore International Mediation Institute since 2016. LKE is the commercial mediator of the panel of International Mediator and Arbitrator of Indian Institute of Arbitration and Mediation since 2019. He has also been the commercial mediator of the panel of the China Council for the Promotion of International Trade, China Chamber of International Commerce Mediation Center, CCPIT, CCOIC, Mediation Center, and a mediator neutral at that point of the World Intellectual Property Organization, or WIPO. Let us all welcome the mediator himself for this session, Mr. Lee Kong Eng. Mr. Lee, take it away.
Thank you, Barry. Good morning, everyone, or good afternoon, depending on which part of the globe you are now. Well, I'd like to say that IFACA is a block of 19 country contractor association, but I just heard from the president, it's in fact 20 country. And the country range from as far as from India and to the other side of the globe, New Zealand. But I've looked at the registration list this morning, and I noticed that there are participants coming as far as UK. So I'd like to welcome all the participants to this webinar. Okay, the topic that I'll be covering today will be split into 8 parts, but I think it will be 7 parts because the Q&A will be taken together at the moderating session. So I will have part 1 of introduction, part 2 of process of mediation, part 3 types of dispute, part 4 documents and information for mediation, part 5 when to initiate mediation, part 6 mediated cases, where I will cover some 20 cases, and part 7 mediation metric. On part 1 on the conflict and dispute, there are actually many definitions you can find, right, from books, right, from the internet, or from many different speakers. So I actually basically simplify the definition of conflicts and dispute, where conflicts as the subset of dispute. But I want to make some clarification. Basically, conflicts and dispute are being used interchangeably. And also, there are many different scholars books, or even presenter, they might adopt that dispute is a subset of conflict. Likewise, there are also other scholars, books, and presenter. They adopt conflict as the subset of dispute. And for me, I adopt conflict as the subset of the dispute. And you will follow how I frame this when you follow me on the presentation. But what I want to say is that my presentation is based on my some 30 years of mediation experience, mediated some thousand, or in fact more than 1,000 over mediation over the period of almost 30 years, big and small mediation ranging from commercial, consumer, community, and family dispute, and also including splitting couples, and as well as boyfriend and girlfriend relationship. And for this over 30 years of mediating experience and the mediated more than 1,000 cases, I've actually consolidated and crystallized my own definition of conflicts and dispute, where I want to share with you that maybe you can never find it in any books. So in conflicts, I have a Chinese word for that. I call it 分歧. And I know that today there are also many Chinese participants, and I noticed that there are also participants from Hong Kong and maybe from China and Singapore. So the definition for conflict that I adopt is different in views, opinions, approaches in handling a matters, beginning with a simple different in views, opinion, approaches on one matter to several matters over time. So whenever the matters or matters are at its original state, it is reckoned as conflicts. Okay, what is dispute? A dispute is an accumulation of unresolved conflicts over time. All right, I call that initial dispute, and I give a Chinese word to it, 纷争. And by the way, the Chinese word that I used on 纷争 in dispute, probably when you go to dictionary, you may find others translation, all right? Like 差异. Of earlier on when I talk about conflicts, I use 分歧, all right? If you go to the dictionary, you can find that conflicts is being translated, all right, into 矛盾. But why I adopt 分歧 and 纷争? So follow down on the dispute definition, or let me reread again. A dispute is an accumulation of unresolved conflicts over time, initial dispute, where the dispute aggravated into a chain of events between the disputant in two problems of multiple dispute, i.e. the issues, whenever the dispute remain unresolved. And I give it a name called serious dispute. In Chinese, I translate it to 纠纷. But then I want to stress that the word serious dispute, the word serious, I don't really mean is adjective of dispute. To me, what I meant is be serious with dispute. So coming to the Chinese part, 纠纷, serious dispute 不是严重的纠纷, right? 是要重视纠纷, so 重视纠纷就是 be serious with the serious dispute. And also, why did I adopt conflict as 分歧, initial dispute as 纷争, and serious dispute as 纠纷? I deliberately chose these three Chinese words is because if you can look at the three Chinese words, there's one common pronunciation called 分. All right, although they are written slightly differently, but this 分 pronunciation is the same for all the three terms I've given: the conflicts, the initial dispute, and the serious dispute. So much so that, all right, for whoever in the practice of mediation or the user of mediation in the conflicts and dispute resolution management, you will then adopt this common Chinese three terms. Why is it important to know the conflicts, to know the initial dispute and the serious dispute before the party will enter into the mediation? I give you one case that I've mediated many years ago. I was being assigned a very big commercial dispute. Right? When the document came to me, I read the document, right? And I went on the mediation session. Having read the document, all right, more or less, I already discovered that this is not just a common serious commercial dispute, but it indeed was a very serious dispute on family or serious family dispute. So much so that that dispute, before coming to me for mediation, the parties are already over it for 7 years. And for 7 years, they were not talking and only communicating through lawyers' letters or legal letters. So when the mediation session was convened with me, I make it a point, right, to make the party understand or know what was their conflicts, what was their initial dispute, and what was their serious dispute. And having all the party be aware and acknowledge during the mediation session that what were their conflicts, their initial dispute and serious dispute. Then my job as a mediator to problem solve their problem become much easy. And in fact, before I could actually settle the case, the disputing faction, right, of two big factions, they were already talking about the coming family gathering. So you can imagine, right, how the mediation for such a serious family dispute was able to be resolved, and is able to be resolved, or not because the party acknowledged there were conflicts, there were initial dispute, and there was serious dispute, right, that helped them, right, to navigate through the mediation. Well, I'd like to give you an example of conflicts, and there are so many. I'll read you one or two, such as disagreement, disapproval, right? Don't worry. I believe the IFACA will probably be able to provide you my slide if you request them. Okay, my example for dispute are also a lot, and I read to you one or two. It can be acceleration of cost, authority approval, bad charges, and etc. And there are more examples of dispute, right? It can be like material supply, non-payment, variation, and a lot more. Okay, now we then come to mediation. Right? Having known what is conflict, having known what is initial dispute and serious dispute, then we come into the mediation proper. But I'd like to cite what our esteemed speaker, King Ho, he has mentioned that contract administrator is good to know or have the skill of mediation or mediation skill. And therefore, I would think that if they are in the webinar now, they might find this webinar on mediation is useful. So basically, I adopted three definitions, one from the Center for Effective Dispute Resolution, CIDA 2013, and another from Singapore Mediation Center, SMC, in 2013. I will not read to you the definition, but I will tell you that the extent of the three definitions which is similar is that mediation is conducted confidentially. You need a neutral third party who is the mediator, whereby the mediator will assist the party in finding a solution. So in a nutshell, this is the mediation of mediation. Okay, the feature of mediation. Mediation is all about voluntary, right? Both parties have to come into the mediation voluntary and not by force. Consensus, confidential. That means whatever the mediation process, right, and whatever is diverged in the session, all right, the party are not supposed to diverge to other party. Listening, communicating, right? This is the opportunity where the party were able to communicate to each other. Like the case I've said, for 7 years, they have not been communicating except lawyers' letters. And in the mediation session, the party will then be able to understand each other, all right, having able to communicate. And thereafter is the problem identification, and then the resolving dispute. And last but not least, all right, the party will have a way, right, and the will, right, to eventually, right, go through with the mediator where he facilitate, right, through the process for the party in mediation. I'd like to introduce to you mediation standard, right, and this standard is what we Singapore we are adopting for all our accredited and certified mediator. So in Singapore, mediators are generally trained and accredited by registered training provider, RTPs, certified by Singapore International Mediation Institute, SIMI, in short, we call it SIMI. Mediators work under an agency of registered service provider, RSP, certified by SIMI. So the mediators from SIMI, RSP are mediators being assessed by their respective agency as being able to conduct mediation effectively. This assessment includes documented process for selecting and appointing appropriate mediators, thus ensuring a certain level of quality in mediation. Mediator, when accepting an assignment to mediate, has to ensure that he or she has no conflict of interest on the assigned mediation case and the party involved. Mediators conduct in a mediation have to be impartial to the party. Mediators are to adhere to certain mediation principles on, among others, confidentiality and voluntarism by parties in reaching settlement, i.e. settlement agreement, which must be signed with each party voluntarily without coercion. Semi-accredited mediators are bound by a code of conduct which incorporate this principle. So what in Singapore we are encouraging that in mediation, right, the mediation, right, will be conducted under the framework, right, of a certified or accredited mediator certified under SIMI, right, and it's encouraged that party who actually going for mediation use, right, accredited or certified mediators. I'd like to introduce to you, all right, the Singapore mediation legislation. Okay, the Community Mediation Act 1998, which come into force 9 January 1998. The Community Dispute Resolution Act 2015 came into force on 1st October 2019, which introduced on mandatory mediation. The Mediation Act 2017, all right, came into force on 1 November 2017. And then the newest Act, Intellectual Property Dispute Resolution Act 2019, was assent on 29 August 2019. And the most significant mediation act in Singapore is the Singapore Convention on Mediation Act 2020, which came into force on 12 September 2020. And in fact, in Singapore, we just completed our Mediation Convention 2022 on the 2nd of September this year. And I'll be introduced to you, all right, about the Convention on Mediation. So you can see from this photograph, all right, this is the group photograph taken on 7 August 2019, all right, for the signing ceremony for the Singapore Convention on Mediation, whereby, all right, the signatory were standing at the stage taking this photograph. And it happened that you can see our Prime Minister, the representative from United Nations, and obviously I have the privilege, all right, to take photograph with some of the signatory. Okay, I'd like to go through this information with you, which is very current because the convention just ended on 2nd of September, which is just a few days ago, and I'm able to extract all this information, right, with very current information. So by United Nations, the 73rd General Assembly Resolution 73198, the convention was adopted on 20 December 2018. And thereafter, all right, the signing ceremony in Singapore on 7 August 2019, about a year later. And during that 7 August 2019, there were a total of 46 signatory countries. And in order to have the next stage, all right, 12 September 2020, for the Singapore Convention on Mediation to be enforced, which is a UN treaty, it required at least 3 signatory countries to have ratified, all right, the signatory before the convention can be enforced. And prior to 12 September 2020, Singapore and Fiji happened to be the first 2 countries to ratify on the same day on 25th February 2020. And the third country was Qatar, which actually ratified on the 12th March 2020. And thereafter, even before the enforce on 12 September 2020, there were several other countries that have ratified that as well. And therefore, all right, till now, as at 31st August 2020, all right, the country ratified as signatory was already 10 countries. And as at 31st August 2022, the signatory country has increased from 46 to 55 now. I will give a quick flash for you to see which are the countries involved. Okay, this is the list of 55 countries, of signatory country as at 31st August. And if you can see why I have some in purple color. Those in purple colors are Africa country members. And you can see that there's a country, China is in green. And why is it not in purple? It is because China is not an IFOCA member, but Hong Kong is an IFOCA member. And it happened that Hong Kong is a province or a country part of China, and therefore it comes within the purple color. The next country I'm going to show you, they can list down the 10 countries, they have ratified. And you can see that it's only Singapore is in purple color, and it's because out of the 10 countries that ratify, only 1 country from the IFOCA country bloc has been ratified. So this is the update, on the Singapore Convention on Mediation, very current, as at 31st August 2022. Okay, coming to part 2 on the process of mediation. The process of mediation are basically the mediator's opening statement, the party A opening statement, and party B opening statement. I simplify it to have only 2 parties, but in fact, in the mediation, there can be many other parties, A, B, C, D, E, F, G. So the next stage of a process of mediation is identification of issue, or we also call it agenda setting. The next stage is exploration of the issues, and then come down to the next stage, private session, or we call it caucus. And then they follow by joint sessions, and eventually, the closing of the mediation, whether the mediation is settled or not settled or adjourned. The part 3 that I'm going to talk about is on type of dispute. The type of dispute, can be business venture, landlord versus tenant, land and property, construction, industrial accident cum insurance, consumer versus vendor, renovation, employment related, family cum commercial, family cum property, neighbor and neighbor, harassment, defamation, assault, and many others. But what I want to introduce to you, the type of construction dispute, it can happen between employers versus main con and the subcon, or main con versus the supplier, or main con versus the subcon, including the suppliers, and subcon versus subcon, including supplier. And for dispute, of this type, the feature of dispute are mainly on quantum claim, that means dollar and cent, or time claim, such as EOT claim. And in such a dispute, normally they are of 2 parties. The next type of construction dispute I want to introduce is MCST versus developer, main con, various subcon, and the various consultant. All right, MCST basically are for the condominium. They are known as the management council of structural title. And for this type of dispute, the feature of dispute are normally involving workmanship, quality of works, supervision, defects, normally many parties. So in my experience, for this type of mediation, the biggest case that I've done is involving child party. And child party, each party are represented by a team of lawyers, not one lawyer, but a team of lawyers. And each party come with their expert, come with their own staff. So you can imagine the case that I managed for this MCST, was about 40 to 50 or maybe 60 party all in one room. So much so that the chamber have to be 2 chamber open up into one. And yet the party not only seated 1 round the big table, they seated 3 round the big table, because there are 40, 50 or 60 of them, which I can't really remember how many were there. Okay, the third type is third party versus main con. And the third party basically are the property owner. And the feature of such dispute can be damage of their property. And this type of dispute can be easily also a multi-party. But I would like to differentiate between a multi-party and a many-party. Multi-party is not as many as child party, but it's definitely more than 2 parties. So it can be a region of 4 or 5 parties involved in this type of dispute. All right, part 4, documents and information for mediation. All right, again, our esteemed speaker, Ken Ho, has also spoken that document is very important, especially for contractors. All right, make sure that all the documents are available, are kept, are complete. So much so that in case that the party required to go into the mediation, the document and the information are useful for the mediation. So these useful documents and information for mediation are as follow. Approval document, costs, correspondences, drawing, defects, LD and EOT, progress, payment, party for mediation, workman, works, work record, work done record as well. All right. So such document, to note that basically, the document and the information are not for evidence, but for facts finding. So this has to be differentiated between adjudication, arbitration, or mediation, where documents are used for evidence. But for the purpose of mediation, document and information are mainly for the purpose of facts determination by the mediators or the party involved during the mediation. Okay, this part 5, when to initiate mediation, is something that I want to share with participants, because many a time when, as a user, because although I'm a mediator, but in the past when I was working, my company also involved in dispute that want to go into mediation. And the very common question, to the user is that, when can I initiate the mediation? How early, how soon, how late? So this is the difficulties. So I want to take this opportunity, to share with you when can a parties initiate mediation. As early as a conflict's been occurred, the parties can initiate mediation. When the conflict developed into a dispute, an initial dispute, if you miss the conflict stage, at the initial dispute stage, the party can decide to initiate the mediation. Or even in a serious dispute state where dispute develop into a chain of dispute, or when the negotiation fail, because party may try to negotiate between themselves, and when the negotiation fail, then you find out, okay, let's go for mediation. Or when realize relationship preservation most important, where the parties may then discover that, well, I still want to have working relationship with the other party, and it's better to have it, for mediation, because mediation, among others, is confidential. 6, will be when realized confidentiality prevail over publicity of the dispute, which I just mentioned. 7, when the party realize the cost of mediation not higher than adjudication, arbitration, and litigation. All right. I think many of you in the industry will know that litigation and arbitration is never cheap. But in the recent year, there are more and more countries are adopting adjudication, all right, like in Singapore, like in Malaysia, in Hong Kong, in England, Australia, New Zealand. And to be frank, adjudication is in fact also not very cheap. So when mediation, all right, or when the party realize that the cost is of importance to them, then mediation should be a better ADR method. 8, when there is a need to dispose of the dispute ASAP, all right, in mediation, it can be mediated within a day, or at the most, to me, 3 days, all right, the dispute is being disposed. Unlike even if it's adjudication, which you just heard, all right, from Jun Yang, all right, in Malaysia, the SIPA adjudication, all right, can take easily 100 days, or in Singapore, at the most is about 1 month, or maybe subject to EOT, slightly longer. Number 9, when party discover that there's no contractual or legal case in their dispute, and then mediation may be a very good avenue for them to look at their problem solving. Number 10, before adjudication, party can go into mediation. Number 11, in the midst of adjudication, does not mean that when the parties are involved in the adjudication, you can't do any other more dispute resolution. You can, in the midst of adjudication, party can initiate mediation. Even in post-adjudication, for example, the parties already receive the adjudication determination, or in Malaysia, adjudication decision, party can still initiate mediation in view that they try to hold on to paying out the payment. Before arbitration, also can initiate mediation. During arbitration, and something new, number 15, post-statement of claim. Singapore Court Directive with effect from 1st April 2022. Singapore is very pro-mediation, By the direction of the court, all the disputing parties, that would like to have their case being litigated, will have to attempt mediation as the first avenue, in the form of a statement claim. Does not mean that the parties in the litigation that cannot go straight to the litigation. They can file for litigation, but they are by this direction encouraged to attempt mediation as the first cut, starting from 1st April 2022 in Singapore. Pre-trial conference, PTC, even when parties already enter into pre-trial conference, parties can initiate mediation, or at time during the pre-trial conference, the registrar will suggest or encourage the party to go for mediation. Even during litigation, party can consider initiating mediation. And how about during litigation where a stay of proceeding has been ordered, party can also initiate a mediation. Particularly when the stay of mediation, we are referring then when the contract mandate that the party have to resort to arbitration first, or the party bypass the contract provision and went into litigation, by application of certain parties, the judge may order for stay of proceeding for the party to return back to arbitration. And at the state of this arbitration, at the state of proceeding, the party can initiate mediation. 19, before discovery, during the litigation, before discovery, party can initiate mediation. After discovery, also can. Before the first hearing at trial, they try to see whether the party can cut costs. So if mediation can allow their dispute to be settled, then the first hearing, can be disbanded. 22, will be in a situation where the client lawyer asking for second tranche of payment. So normally when a party will go to trial, you definitely have a lawyer, and you probably have already paid a certain amount of money, but still not knowing that your case in trial will win. all right, and the client lawyer will probably ask the client for money because if the payment is soon depleting, so the client may want to consider, instead of paying the second tranche of the payment to the lawyer, all right, he can initiate mediation, and when his mediation is convened and happened, there's luckily there is a settlement, then he don't have to pay the second tranche to the lawyer. All right, 23rd will be order by judge. All right, High Court judge, especially in some of my mediated case, all right, they will refer by judge, order by judge for the party, all right, to initiate mediation. 24th is just before final submission at trial, all right, just before the party's lawyer going to do their final submission to the judge for the judge to make a judgment. All right, they can quickly initiate mediation, and mediation can be convened. And if there is settlement, all right, the trial can be discontinued. Okay. Last but not least, all right, mediation can be initiated practically anytime if you can think of. And this, the 25, all right, circumstances that I can think of, and that could actually be more, or practically anytime the party can initiate mediation. Part 6, mediated cases. Right, while this platform, IFACA, we are a contractors association, I will be sharing a lot of construction-related cases which are mediated. I will also be sharing some other nature of cases where I have mediated, so that this big spectrum of audience here, right, can have an idea what are the cases can go to mediation. And because of in lieu of time, I will not be able to discuss each and every case in detail, because to discuss each and every case in detail, each case may probably need a few minutes to an hour. So I will left with probably another 15 minutes to go. All right. I will quickly cover the 20 cases, all right, quickly, and introduce to you what are the cases that can be mediated, although I've actually mediated more than 1,000 cases. Okay, the first case I'm going to share is on construction damages dispute. Case number 1, the parties are actually third party, factory owner versus main contractors. The number of parties, there are 2 parties, but 1 party is involved, insurer. All right, the other parties involved are the lawyers, expert, and the experts are civil structural engineer, and they are all professional engineer, PE. And the project involved, all right, was public sewer work. The subject matter of this dispute, all right, were actually based on recollection. All right, the third party claims against the main contractors for damages caused to third party property, which is an office and factory premise, which was caused by purportedly negligent excavation and pipe jacking work carried out by main contractors that resulted in land subsidence, gradual settling, and all sudden sinking of the earth's surface owing to subsurface movement of earth material, causing the column tilted, beam and slab damage. The building was rendered unsafe for occupation. It involved expensive manufacturing equipment and machines inside the building. Third party aver that they have incurred property damages at their premises. The dispute amount ranged from 5 million to 10 million Singapore dollar. Why is it such a big range? Right? Because the initial claim, right, was only the damage of the building, but the building does have the content, and the contents are very expensive manufacturing equipment and machine. So through the mediation, right, the quantification of the damage has increased from 5 million to almost 10 million. And this mediation duration took 2 days originally, but it was then extended 1 more day. So this mediation is actually conducted in a full 3 days. Okay, the issue involved on this dispute is pre-existing condition of factory, 2, damages and loss, and 3, damage condition. Okay, the others I want to add on is this particular mediation. Before settlement, I spoke to 1 party in Mandarin. So not necessarily the mediation can be in English, or it can be in other language or dialect. Okay, the next case I'm talking about is industrial accident dispute. Case number 2, the parties were workers versus employer and insurer. So number of party 3. A party involved were lawyers, workers' family members, and employers' family members. So note, the workers lying on stretcher came by ambulance with nurse standby outside. So imagine the parties or the party's lawyer, you're trying to illustrate, all right, to the mediator how serious and how bad is the condition of the victim or the worker. The subject matters was the workers is paralyzed from waist downwards, inflicted from work accident when the handling machine dropped onto the workers when these workers was working. So a total of 3 workers injured. 2 workers accepted the workman compensation, but these workers suing employer instead of recovering from workman compensation insurance. So the dispute amount was more than $500,000 Singapore dollar, and the duration was 1 day. The issues were injury and compensation. And this case, all right, I've actually mediated in Hokkien, all right, to the employers and to the workers in Mandarin and to the others in English. So you can imagine in this mediation, I have to use 3 languages at one go. Okay, the next case I want to share is land share dispute. Case number 3, the parties involved are landowner 1 versus landowner 2. Number of parties, 2. Other parties involved were lawyers, both landowners' family members. The projects is on a land for fish farming. The subject matters are landowner 1. Johnny bought a piece of land with a partner. The partner quitted the deal. Landowner 1 found landowner 2 to jointly buy the land. Landowner 2 paid his portion partially, and as such, landowner 2 then had to pay rent instead, being not an equal share landowner. But quarrels ensue frequently between them for late and non-payment of rental by landowner 2. So the dispute amount was less than $500,000 Singapore dollar, and we took 1 day to mediate, and the issue was on rental and buyout. And this mediation was mediated fully in Hokkien, including the lawyers are also speaking totally in Hokkien in this mediation. And this is 100% Hokkien mediation. This next case that I'm sharing is on construction defect dispute. Case number 4, right, the parties were MCSTs versus developer, consultant. MC is the main con, SC is the subcon. The number of parties involved, 12. Other parties were lawyers and expert building surveyors. So that is what I have shared with you earlier on. All right, there are 40, 50 to 60 people in one room, all right, sitting 3 around the table. And this is a condominium project. And the subject matter was the MCST claim from developer defects to external cladding and plastering cracks, latent defects, and design deficiency. The developer employer joined their consultant and main contractors, and the main contractor then joined their subcontractors for the dispute. All right, the dispute amount was exceeding $1 million Sing dollar. And this particular dispute was originally scheduled for 2 days, and I will dispose it in 2 days. All right, the issue involved was latent defects and compensation. The next case is on construction payment dispute. Case number 5. The parties were main con versus employer ministry. Number of parties are 2. Other parties involved were lawyers, expert, all right, they are professional QS, architects, M&E, professional engineers. All right, this is a very high-profile institution project. The subject matter was main con claiming less on meter works, entitled more EOT, less LD, and dispute in final account. There was issue on EOT notices that is condition precedent under the form of contracts. The dispute amount was exceeding $5 million Sing dollar, all right, and we mediated using 2 days. The issue involved was 1, on meter works, 2, EOT, 3, liquidated damages, and 4, final account. The next case is on construction rate dispute. Case number 6. Parties subcontractors versus subcontractors. Number of party, 2. The other parties involved were the lawyers, project managers, engineers, and commercial manager. All right, this is an oil and gas project. The subject matter was that the subcontractors undertook 3 projects for subcontractor. By purchase orders, the works were priced in unit rate, which is in dispute for modification and additional or variation work, whether should be measured by man hour and not unit rates. All right, so there's a dispute, all right, whether to claim using man hour or unit rates. And this is very common, all right, in construction dispute, where again, King Ho has spoken about that. The dispute amount, all right, was less than $1 million Sing dollar. All right, mediation period was 2 days. The issue was rates versus man hours. All right, to note on the others is an urgent mediation prior to court hearing very soon, ordered by judge. In fact, I conducted the mediation within days after being appointed as mediator. The next case is on construction scope dispute. This is a partial online mediation. When I say partial online mediation, that means one of the session, all right, is face-to-face, the other session is by Zoom. Okay, case number 7. The party involved were the subcontractors versus the subcontractors. 2 parties involved. All right, the other parties were the lawyers, contract managers, and commercial managers. It's a condo projects. The subcontractors, for the subject matter, the subcontractors are supposed to supply and install window. Dispute over removal of protection and cleaning works fell within the subcontractor original scope of work, as actually claimed by the subcontractor. The subcontractor then assert that this work fall within the subcontractor's original scope of works, that the subcontractor failed to perform the works, and that the subcontractors has thereby suffered loss and damage. The subcontractor denied that the subcontractor's back charges claim and counterclaim for payment due from the subcontractors for work done under severance variation order. The subcontractors also deny any outstanding payment claim. This dispute involved less than 1 million Sing dollar. 2 days, because 1 day is face-to-face and the other days is by Zoom. The issue involved was back charges and payment. The others are, the mediation is conducted in a mixture of Mandarin and Hokkien. The first session was online mediation, and the second session is a face-to-face mediation. Okay, the next case is on family allowance dispute. As you said, no, I'm also a family mediator. Case number 8. The parties was a 80-year-old mother, grandson 30 plus versus daughter and son. They are all 60 plus years old. So there are a total of 6 parties. The other party involved was interpreter for Hainanese dialect. So for your information, I do not know Hainanese dialect. This particular case, the accommodation of the mother was the old folk home. The subject matter is, this is a remediation on variation of tribunal order. The first mediation was not mediated by me. The first mediation outcome was no settlement, resulting in commissioner of the tribunals set out an order for all the 4 children. A few of the children unhappy with the order and filed for variation of order. As such, the second mediation convened, where the tribunal specially selected me to mediate. But I don't understand Hainanese. The applicant, a father or mother case, has hearing problem, and can only understand Hainanese dialect. As such, Hainanese interpreter was deployed. The applicant cannot understand interpreters Hainanese, where the interpreters similarly cannot understand applicant Hainanese, because applicants spoke market Hainanese, while the interpreters only understand official Hainanese. Trouble grew up at that point of the time. Mediation proceeded after lunch without mediation, without interpreter. Since the interpreter is not very helpful, I then released the interpreter from the mediation, and I proceeded with the mediation without interpreter all right, with mediator able to find a middle ground for the children, all right, the mothers or father, and the grandson, hence reaching amicable settlement. The tribunal set out a consent order in accordance with the settlement agreement. Okay, this dispute amount is a few $1,000 Sing dollar per month, all right, mediated one day. The issue is on the maintenance of the old father. Okay, the note, all right, the Hainanese, Mandarin, and English, all right, for this mediation, all right, to the interpreter in the morning and no interpreter in the afternoon. Okay, the next case I'm going to talk is on religion and racial dispute, and this is quite a sensitive dispute. Case number 9. All right, the party involved was a man, a minority race person, versus a renowned religion practitioner, attended mediation wearing the religious robe. All right, it's actually a home-based practice. The number of party involved was 2. All right, other party was there was an observer from the ministry. All right, the accommodation involved is public housing. The subject matter was this is a remediation where the first mediation settlement agreement terms and conditions were breached. The first mediation was not conducted by me. The minority race man cannot bear with the daily and periodical religious rights and rights, respectively, of his immediate next door neighbor. The rights of burning of religious items produce smoke and rights, produce noises, all in the respondent flat where were unbearable to the man and his family. The burning of the done rights item outside but near their flat produced extremely pungent smell to the man, being a minority race not acquainted with the respondent religion. The dispute amount, this is neighbor dispute. There's no money involved. The mediation duration was less than 1 day. The issue was on smoke, noises, and smell. Note, selected me for this mediation, for this remediation, because I'm proficient with the religion. Because in this type of dispute, domain knowledge is required. So the centers has requested me to mediate because they know that I'm familiar with this particular religion. And next, the mediation was conducted in a mix of Mandarin and English, since they are two disputants from two different races. Okay, the next case I'm going to talk about is on family cum property dispute. This is 100% online mediation. Case number 10. The party involved was a plaintiff living in country C, province A, versus the first defendant living in Singapore, the second defendant living in country C, but in province B. So there's a total of 3 parties. The lawyers are also there, everyone online. The project involved a condo. The subject matter was the plaintiff married her Singaporean husband, deceased, in country C. The husband bought a condo in Singapore in his sole name, but plaintiff paid for 20% of the condo. The husband has a brother living in Singapore, first defendant, and another sister living in country C, second defendant. The husband has a will, which the first defendant being the executrix of the will, while the second defendant is the beneficiary of the husband asset, both in Singapore and country C. Plaintiff is suing that the Singapore property in her husband's sole name is a plaintiff matrimonial house, and plaintiff entitled to the whole condo completely and cannot be willed out. The dispute amount is more than $1 million, a Singapore condominium, worth somewhere there. So it took 1 day to mediate. The issue involved was property listing in probate, and 2, the property itself. This was a 100% Mandarin mediation, the party dwelling in 3 separate locations of the country. Next case is on consumer goods dispute, as I'm also a consumer mediator. Case number 11. The parties involved are the initiating party, the consumer, versus the responding party, the vendor. The number of party involved are 2, and projects are the house, the initial party's house. subject matter is the initial party's house. Initial party bought a sofa set. Upon delivery, the defects found on sofa, the responding party brought back the sofa in parts to repair. After repair, the sofa developed alignment problem, where the initial party complained original defect was not rectified and now got further alignment defects. The initial party wants the defects be fully rectified plus extended warranty or refund. Respondent party alleged this is wear and tear. Right, the dispute amount was less than $5,000. All right, we took half a day to mediate. The issue involved was refund, all right, of the sofa set, defect to repair the sofa, but the counterclaim is it was wear and tear, and one of the party, the consumer, want an extended warranty. Okay, the next case is
Mr.
on workplace assault dispute. All right, this is a workplace dispute. By
Mr.
case number
Lee,
12.
sorry to interrupt, but you only have 5 minutes left.
Okay, then I will go through the heading we'll do. So our talk on this workplace dispute is basically between two individuals, right? One from PRC Chinese and the other one from the Vietnamese. The next dispute is on consultant dispute. Right? It's a construction dispute between the employers, right, versus consultant. Right? This particular case is being disputed because they want to do it urgently because the stage is at pre-discovery stage, right, where it's an urgent mediation with pre-trial conference coming very soon. The next case is on the workplace artist dispute. That means between actress, right? It's between the actress and their talent agency, right? Basically, the actress has actually been deployed to play an acting role, but she was not paid, right? Amount less than 20,000. The next dispute is on defamation. All right, the applicant is an album singer, right, and the respondent is a company director, right. The subject matters, I will not read to you. If you have the case, you will have it. Basically, this is a defamation statement dispute whereby it was then mediated within half a day. The next one is on indecent content in social media. This particular case between the foreigners and the foreigner, whereby some photograph, all right, indecent photograph was posted in the social media, right, in a very compromised position, right, whereby I mediated this case. It's also a magistrate complaint. The next one is on renovation repair dispute, online mediation. All right, it's between neighbors and neighbors. It's on landed property. All right, this particular case basically not involve the repair. Not involve the defect. The contractor is willing to repair the defects, but it's the respondent that is a little bit greedy. All right, he does not want the repair method offered by the contractors, but he wants his own repair method that amounts to improvement of work. The next case is on shareholder buying out dispute. All right, it's between a plaintiff and the first defendant and second defendant, three parties. All right, this is actually company dispute. Commercial company involved 3 to 5 million. The next one is on purchase of property dispute, whereby the purchaser, the husband and wife, and the developer involving a condo unit, less than $500,000, right, whereby the plaintiff tenant threatening to terminate the tenancy on the defect if the house is not being rectified, where the purchaser refused to pay the last payment to the developer when buying this condominium property. Okay, this is the last case. All right, it's between the subcon, which is the foreigners, versus main con. They are both foreigners. All right, one party have lawyers, the other party does not have. The subject matter is on earth slope stabilization works, require shotcreting works, very extensive and voluminous amount of mortar used for shotcreting. All right, they involve a lot of variation claim. It's more than $5 million, 2 days to mediate, issues on rate and remeasurement. All right, the party here threatened to walk out many times, and this is a very typical curse of the last mile case. Okay, I quickly go through these motivation consideration factors, all right, for success mediation. They are basically interest versus position, consent issue, communication, understanding, option solution, alternative, criteria, relationship, commitment, intention, and phase aspect. Okay, I'd like to show you this metric. All right, one is before mediation, one is after mediation. But what I want to stress to you that in mediation, we all wanted to achieve all win. All right. And if we cannot achieve all win, we want to achieve happy win. And if not, just win. And for all win, right, we want to go by the collaboration type of mediation mode, or if not, the compromise mode. All right. And then if not, you can use the accommodate mode, right, to achieve just win. Right. But normally in the mediation, right, we will not want to achieve, right, no win. Because if you go for no win for mediation, you might as well go for arbitration or litigation. All right. But obviously the third best is me win, avoid. But obviously this is not the best. So in mediation, right, we always tell the user, try to achieve at least a compromise. But to a mediator, what he would prefer to adopt a collaboration mode. So very quickly, all right, I've actually covered my whole presentation. And just a note, all right, the extract are based on memories. Because some of the case I exposed at 20 over years, and there might be some inaccuracies of facts and the mixing up of identity, if any. Okay, we'll leave the question to the moderation session. Thank you.